Hi and welcome everyone. We're going to give a 5 minutes before we start and let people join in. Thanks for joining promptly.
So good afternoon, everybody. Those who've joined already, we're going to leave it open now. People are still piling in, so just a few more minutes. We'll start between now and 5 past. So now would be an opportunity to go and get a cup of tea or coffee, whichever is your choice, or cold drink, and then settle in to the subject. So yes, we'll come back to you in a few minutes. Thank you.
Hi, Derek, can you hear us? Just because, yeah, we haven't said, we just welcomed everyone. We haven't started yet. We're just waiting for more people to join. Can you still hear me clearly? Perfect, thanks.
We'll start in about a minute. Okay, so welcome everyone. Looking forward to an interesting afternoon. Just on, for those interested in history, today is the National Day in the Ukraine. And on the 24th of August, 1991, they gained their independence from Russia. And that didn't really work out much, but anyway, just for those who are interested in a bit of history. So welcome. Thank you, Edwin, for joining us today and for conducting this session. Always interested in ethics and the different codes of conduct, etc. I suppose everybody has a different view, but this brings us back to the need for a code of conduct. And I'm not going to waste any more time on the introduction. I look forward to this afternoon and welcome, Edwin. The floor is yours.
Thanks, Stan, and good afternoon to everyone. Just maybe from an administrative point of view, I'm going to be running for an hour. We'll then take literally a 5-minute leg stretch. So somewhere around about 2 o'clock. We'll then run for another hour. We'll take a sort of a 10-minute tea break. I just find the 2 shorter breaks works better when we're presenting it online. So I hope that's okay with everybody. And then, yeah, if you, Danny, are you going to be just checking the questions? I'll also try and watch them a bit.
Yes, I'll keep an eye on the questions in the chat. I'll let you.
Great. Thanks. And then, yeah, if you are, I'm not sure, can the participants unmute themselves?
No, so the participants would either need to raise their hand, but I like to prefer to keep that to the end because I'm not too sure about muting them afterwards.
Okay, fine. Okay, thanks then. Great. So then I think in the interest of time, let's get on with today's session. Maybe before we start, just like to understand, we've just got just over 30 people with us. And if I can ask you if, first of all, if you can just raise your hand and just keep it raised if you are a member of a professional body, like SAICA or SAIPA, CIMA, etc. If you're a member of a professional body, can you just raise your hand?
A lot of hands going up in the chats.
Okay, great. Thank you. Just keep your hands raised. Okay, I've got 13 of you. Thank you. Great. Thank you. And then I just also want to understand if any of you online today are registered auditors. Anybody a registered auditor? If you can raise your hand now. If you're not a registered auditor, if you can please lower your hand so that I just understand of sort of the extent to which we've got people that are registered auditors. Great. Okay, so thank you. Appreciate your responses. So let's then get on to the agenda for today. What we're going to be looking at is who writes the Code of Ethics. And I was discussing with Stan just before we started, you know, why do we actually even need to have a code? You know, surely people have got their morals and values. So why do we even need a code? We can address that as well. We'll then be looking at the RBA and CICA code. Remember, this is based on the IFAC code, and we'll discuss the differences. For those of you that are auditors, there are changes in the South African Code of Conduct issued by the RBA for registered auditors. But from a CICA perspective, or from another IFAC body like CIPA, for example, those codes are pretty much standard. They've adopted the international code. We'll be looking at the role and mindset expected of professional accountants, and this is irrespective of if you're an auditor. Some new changes to the code that have come in, whereby one needs to just sort of take a bit of a look back, a step back approach to evaluating your ethical decisions. And then we'll be looking at some fee-related provisions. This relates primarily for the independence of auditors, some changes in that regard. And then non-assurance services. While primarily this relates to auditors, I'll even give you a practical example of a non-audit service that was conducted where there were some issues and actually went to a legal case dispute as to whether or not independence had been breached or not. And then we'll look at the public interest entity definition and the implications thereof, because that has different rules around independence, particularly for auditors. So just to understand what it means and what the implications are if an entity is a public interest entity. So if we've got any questions, please, if you can post them in the chat. You know, it's important that if I haven't explained something properly, if you're asking a question, then if you've got one, there may be 30 others of you that have also got a question. Barbara, I don't know if your hand is up for a reason, or is that just an old hand? If you can just lower that. Thank you. So when we think of ethics, I think we all come from different social, religious backgrounds, and therefore we have a different understanding and a perception of what sometimes is appropriate under different circumstances. When it comes to make it a bit more practical, when it comes to something like integrity, honesty, I think everybody on today's training session would agree that, well, stealing is not allowed. But then when you drill into it, well, then you need to understand, well, what is stealing? Is stealing time okay? Is taking an extended lunch break allowed? What about stealing stationery from the office and bringing it home? What about stealing time? So, because our moral, religious, or cultural backgrounds may have a different interpretation of what's right or wrong and what's allowed, so we then have the need for a code of ethics. What the code of ethics does is takes a person's moral duties and obligations and sets out how they need to behave and interact in society. And that's why different professions have got different codes of conduct, different ethical codes. For example, the medical profession, the legal profession, and our profession, the accounting profession. There's different expected levels of behavior when we deal with, for example, confidentiality with a doctor or a lawyer versus an accountant. And therefore, it's important that we have a common understanding and application of how then we need to behave and interact in different circumstances. So when we look at who writes the Code of Ethics, so the Code of Ethics falls under the International Ethics Standard Board for accountants, and the IESBA is the International Independent Global Standard Setting Board, which is located in New York. Interestingly, because the Americans, when it comes to the auditing standards and some of the standards we've got, including our code, actually don't even use it. But that's where it's based, and it sets, in terms of IFAC, it sets the Code of Ethics, and it sets standards which are the cornerstone of ethical behavior in business and organizations to enhance public trust in financial and non-financial information. IFAC is the body in International Federation of Countries, and that has various other subcommittees, one of which is, for example, to set the accounting standards, the auditing standards, as well as the review standard, the compilation standard. All of those standards fall under IFAC. Various member bodies around the world then, such as CICA, CIMA, ACCA, ICANN, all these accounting bodies or auditing bodies around the world, then adopt these international practices. And actually, it's one of the requirements of being a member of the international body is that you will adopt their code of ethics, their education standards, for those of you that are training officers, that comes from the educations department of IFAC, and then the standards are then adopted in different jurisdictions and then sometimes enhanced or adjusted. And in South Africa, for auditors, as I said before, we have the Urban Code of Professional Conduct, which is the IFAC Code of Ethics with additional stringencies to deal with challenges that have been experienced in the local market. So let's then have a look at how the standard is set up. And the IFAC Code of Ethics is set out in such a way that there are specific topics. Some sections contain further details. So, for example, you may have sections around independence, and you may have sections around non-assurance services, and then under each of those sections you may have matters dealing with valuations, taxation, consulting, assistance with recruiting, accounting work, etc. And those requirements with which a professional accountant needs to comply would be set out, prefaced with an R in front of that section number. In order to understand what that section is about, there's often an introduction, and the introduction to the code also sets out the context of the conceptual framework of the ethical standard, which is the guidance around how a professional accountant needs to conduct themselves when facing a potential ethical dilemma. And then we have the application guidance, which expands on a specific requirement to give more information on how such a requirement needs to be applied. So, for example, there may be something around independence, and then the question is, well, when it comes to independence, there's a general principle that's a requirement, but then, if you're dealing with a public interest entity, then you need to do certain things. If you're dealing with a non-PI, then your responsibilities aren't as restricted. And we'll go through some of those requirements as we speak today. When it comes to the IRBA code, for those of you that are auditors, so if there's a standard paragraph that has become part of the South African Code of Professional Conduct for Auditors, the IRBA ethics, so that then doesn't need any change because it's the same as what's in the IFAC code. But where South Africa have made additional stringencies, for example, around company assets or a firm taking on and managing investments of clients. There have been some scenarios where audited firms have run sort of money market trust accounts, or not really trust accounts in terms of the Legal Practice Council, but where funds were pooled together and then invested to earn a better return for their clients. There has been some problems in the past with the administration of those, and therefore South Africa have introduced additional requirements in regard, and anybody who's a registered auditor would need to abide by these additional requirements, and that would be suffixed by a SA after the requirement. You may have rule or regulation requirement 100.10, which is something that is standard, and then you'll have 100.1.0 SA being something that's specific in South Africa. And the same with the application guidance. If there's something at South Africa felt wasn't adequate, that would have been expanded upon in the South African requirements and the South African Urban Code of Conduct. So I hope that's clear. So just the history of the code. So the Urban Code follows the same timelines as the IFAC code, sometimes slightly delayed, maybe by a couple of months. But interestingly, the both SICA and the RBA have they have respective people in their departments that deal with ethics and are involved very much in contributing and speaking and providing feedback on proposed changes to the code where there is concerns around the application of proposed changes in the South African context. So the code in its present format that we have was revised in 2014. Then some 5 years ago, there was the introduction of the independent standards. That's parts 4A and 4B of the code. For those of you that conduct independent reviews or audits, those independent standards are applicable to you. And then there was some sort of restructuring just to make the code a bit more user-friendly and easier to follow. That happened in 2018. And then earlier this year, we have had changes to the code again, whereby a single publication was issued, whereby the code has been revised and additional requirements included based on consultations with the World Bank and the International Federation of Independent Audit Regulators. That's IFIA, a body where, like, the RBA belong to, and they look at concerns around independence and problems that are being experienced, and then put in additional guidance where they find that the profession is not being acting ethically and or interpreting things sometimes a bit too loosely in their view. And then there's also been some subsequent amendments which we'll be going through today as part of the session. So before I start actually going through the code, I'd like to look at some of the inspection findings, both from a local perspective in terms of the RBA's findings, and from an international perspective in terms of the IFIA report, which is the International Federation of Independent Audit Regulators, of which the RBA is a member. And they both publish public, the one's called the Public Inspections Report. The reason we're looking at the 2022 reports for each of them is because they only come out in March 2023. So these are the latest ones. And it's important to understand when we go through the requirements and the deficiencies that have been identified by the regulators, we need to see how then the code has changed because of that, and what's actually where people are slipping up based on the regulations that have been issued. So if we look at The RBA and regulators around the world do two types of reports. They do a firm-wide report where they look at compliance with the quality management standards, which includes compliance with the ethical codes. And then they look at more focused findings on the quality of audit work performed in engagement audit files. And what I've got here is just an understanding of what is considered to be a reportable finding, so that we understand when we look at them what's the result thereof, and we can then drill down into that in a bit more detail. So when we look at the departures, where there is a departure from a system of quality or from the code of ethics or the independent standards, that results in a reportable finding. And the significance thereof is based on how pervasive that is, and whether or not this is something of a systemic nature, happening quite regularly. Perhaps sometimes the underlying cause not properly identified and assessed, or maybe something that keeps recurring. Therefore, it's in this context that the RBA and IFAC issue their annual reports, and in addition to that, they've issued an annual enforcement report, whereby the enforcement report looks at where things are going wrong. And that's what this next slide looks at. And what is very concerning is that 42% of findings related to independence. And we understand that we can see 8% is accounting completion, 3% is this other areas, but it's 42% is independence. If you look at this grey section, 6% relates to non-compliance with laws and regulations. That's another requirement in terms of the code. Other 6% here in this purple section relates to dishonesty. Failure to exercise due professional care and skill is also a fundamental principle of the Code of Ethics. And then professional conduct is this purple section over here, which is also not acting with due professional care. We're saying if we add up the 7 plus 15 is, what's that, 22 plus this grey 28 plus 42 gives us, what's that, 70% of findings relate to ethics. And that's why it's critical that we understand our responsibilities, so that hopefully we can address them and then ensure that we as practitioners don't fall foul of that. Right. You know, what's interesting is each time there's a finding, there may be a number of charges that relate to that particular finding. And therefore, you know, this is a very much a high-level understanding of what the consequences and problems are. So in light of that, let's then have a look at the code and how it's changed. So the first aspect is, since 2014, we've had a new code. The code, because we're accountants, they thought A, B, and C wasn't good, so they went with numbers, something that we relate to a lot easier. And we've got part one, which deals with the general principles. I see Sandra complaining about the sound. I don't know if anybody else is having a problem. Maybe just from a show of hands. Can everybody hear me clearly? You can just raise your hand.
Just to quick clarify, are you raising your hands? Can you hear, Edwin, or are you raising that you having a problem? I think we're getting two mixed signals.
Okay, maybe that's a good idea. Okay, if you can't hear me clearly, so lower your hands, everybody. If you can't hear me clearly, if you can raise your hand. Anybody who can't hear clearly. So it does seem to be a very small proportion. So my suggestion, Danny, we've got 4 people that have raised their hands, is maybe if you just sort of logged out and came back in, hopefully that will address the issue. Okay. So in terms of then the sections of the code, so part 1 deals with the complying with the code, the fundamental principles, which we're going to spend some time on, and then the conceptual framework. How do you navigate through the code? What are the systems, the steps that you need to follow if you're dealing with an ethical dilemma? For those of you that are non-auditors, don't do independent reviews, then part 2 is applicable to you, so part 1 and part 2. Those of you that are registered auditors performing professional services, you've got part 1 and part 3 that are applicable to you. And then anybody doing an independent review or an audit, they would then need to apply parts 4A or 4B, depending on the nature of the service that they're operating, the nature of service that they're performing. For example, an auditor or a reviewer applies part 4A, but if you're doing, for example, a trust audit for an attorney or legal practitioner, part 4B would be more applicable.
Yeah, Edwin, I think it was more when you moved. The sound, it's when you move. I think I'm noticing that your sound goes a bit.
Okay, I don't know. Let's try that. Is that any better now? How's that?
Yeah, as long as you still, I think it's more. If you sit still, it won't fluctuate too much. I think that's maybe what everyone's having an issue with.
Okay, great. Thanks, Danny, for the feedback. Okay, so let's then now start going into some of the details and understanding what's changed, particularly in 2023. So there have been amendments in terms of second opinions. So where an accountant is, or auditor, one of your clients is looking to understand how they need to deal with a certain transaction. So what happens is they're not happy with the opinion that I give, so they'll go to you. And there's specific requirements around those second opinions, when they must be done, what's the process that needs to be followed. There's also been changes to registered candidate auditors. So if you are a training office for professional auditors, for registered auditors on the, the ADP program, I think it's called now. So there's changes that have happened in that regard. And then in part 4B, there's changes to reflect terms and concepts used in the revised ISA 3000 standard, which was effective from June 2021. So that's where you're doing, for example, a trust audit, or you're involved in sustainability auditing. That ISA 3000 is the standard that's used in that regard. And therefore, it's important that we're aware of what those changes are. Then there's also been some revisions to part 1. And the fundamental change is the concept of the role and mindset expected of registered auditors, but all professional accountants as well, whereby a person needs to conduct themselves in a certain way, and we'll have a look at that in a bit more detail. That change has been in place effective from 31 January. So that's from effectively then, sorry, 31 December 2 years ago, or a year and a half ago. So it's been around for a year. That there've been some significant changes, and we'll address that in a lot more detail. And then signing conventions to the reports for professional behavior. More or less the same date as to what needs to be included there. What happens if you've got different people that may, from an independence perspective, you may need somebody to sign off. What are the requirements and what happens over there in those requirements? And then the revisions addressing objectivity of an engagement quality reviewer and other appropriate reviewers. For those of you that are auditors in terms of the International Standards on Quality Management, in what's replaced the ISQC 1, the National Standard on Quality Control, since 15 December last year, there have been new standards on quality management. So an entire risk evaluation needs to be performed before you can just come up with a manual. And as a result thereof, just making sure that independence is addressed in those regards. And then we've got, from the end of last year, 15th of December, we've got additional requirements for fee-related provisions as to what the thresholds are for both firms and individuals. If you've got a significant client, how do you address that from an independence threat? And then the non-assurance services, that's been enhanced significantly to clarify one's roles and responsibilities, address the independence of the auditor, to maintain the independence. And then the final amendment that's come through also in December 2022 deals with the quality management relating conforming amendments, both to the RBA code and the IFAC code, to align the code with the requirements of the new quality management standard. For example, the definition of an external quality reviewer has been included in the URBA code and the IFAC code, and those are also effective 15 December from last year. So that's something that needs to be applied now if you are involved in audits. Right, maybe just a quick show of hands. Is anybody involved in group audits? Anybody involved in group audits? Okay, so we do have one hand raised. Thank you. So I assume that's a new hand and not an old one. So maybe then just to touch on that. So there have been changes to section 400 of the code, which expands the definition of the engagement team, because that would include experts such as external quality reviewers, IFRS experts. They would all form part of the engagement team and therefore would need to comply with your systems of independence. This is effective for audits of group financial statements for periods beginning on or after 15 December 2023. The reason I'm mentioning it to you is because it could be early adopted, and because of the new quality management standards, a lot of people that have put in place their new quality management systems have adopted these new requirements, and that's why I thought it would be worthwhile just touching on them very briefly here today. And then there is also conforming and transitional provisions that need to be applied, dealing with if one started an audit, how does one deal with that and transition to the new standards. So in terms of the international code, be it an accounting, auditing, or ethical code, has actually an additional set of guidance material that is issued with it, and that's the basis for conclusions. And in April 2022, together with the new standard when it was released on the IFAC code, they included in the basis for conclusions a deeper understanding of what the public interest entities were and how that was defined. And, you know, the reason why it was done is because if you're dealing with an entity that has public interest, there's an additional independence requirements because of the reliance by those parties on the work that the professional accountant and particularly the auditor does in that regard. There's the baseline public interest entities, and those can be sort of from a top-down perspective, mandatory categories subject to local bodies, and those entities are, for example, your listed entities, anybody subject to a exchange that has their fund debt or equity traded in a public market. So those are areas in which we are dealing with the baseline public interest entity. In addition, there may be local bodies that are added to that base which additional requirements need to be put in place or need to be complied with because of the public interest nature. And those are, for example, in South Africa, the RBA has defined which entities are deemed to be a public interest entity. For example, mutual banks, pension funds. I can't remember what the number is, but I can't remember it was 50 or 500 million. If they have 500 million of assets under management, you've got these unit trusts, medical aid schemes, etc. All of these bodies, because of their public nature, there's a need that they have these further enhanced independence requirements. And then in addition to these requirements, the entity itself, particularly auditors, would need to include what they deem to be a public interest entity in their scenario. For example, there may be a small audit firm that does, for example, a national audit for, say, the SPCA or something. And therefore, because of the implications thereof, they would then also be treated as a public interest entity. The implications are primarily additional independence requirements and also the extent to which non-assurance services can be exercised to them. So, from the International Code's perspective, this is effective for 15 December 2024. But if you're saying, well, the URBA Code hasn't yet been amended for those changes, but in section 400.8 SA, the code has already been amended in South Africa, the URBA Code, which lists which entities are deemed from a South African jurisdictional perspective a PIE by the audit regulator. And that we've had in place since 2018 at least, if I recall. So therefore, while I would say the international code is catching up with where South Africa is, we've already introduced some of these changes, and this is one of those examples with the public interest entity definition where South Africa has specific guidance that needs to be complied with. In terms of the new concepts and guidance, factors to be considered if an entity is a public interest entity is the financial condition of the entity, no longer referred to as listed entities, but whether they have financial instruments that are publicly traded. And then there have been expansions to include specific industries like insurance entities, where there's a lot of funds from different individuals that's all collated together. And sometimes these organizations, insurance, retirement funds, medical aids can be quite significant players in the market. And then there's guidance given for different jurisdictions and guidance for firms as to how they need to consider what a public interest entity is. And these sort of matters should be included in your quality management system. If you haven't developed one, that's something you should seriously consider and something I could possibly assist you with if need be. So let's now have a look at, I think before we break for a 5-minute stretch, the role and mindset expected of registered auditors. This is also applicable to professional accountants. And that is that in terms of part 1, which is the overall principles, so it says that when a professional accountant is carrying out their services, there is a certain high quality that is expected of the work which they undertake. And this is critical because this tends to improve the confidence in the profession. And it's the reason why businesses, governments, and other organizations involve professional accountants, including insurance and other professional services that are undertaken. What the requirements are of the mindset that needs to be applied is that there needs to be full adherence to the ethical principles, the code, as well as your professional standards, be that auditing, compilations, independent reviews, etc. Then one needs to act with professional due care when one carries out one's services, applying the business acumen that one has obtained. That needs to be applied based on your expertise, incorporating the technical and other matters, so that one can then exercise professional judgment, arrive at an appropriate treatment. So the revisions to part 1 are primarily there to focus, promote the role and mindset of a professional accountant. It's there to reinforce aspects and principles of integrity, objectivity, and professional behavior. It's raising the behavioral expectations of all professional accountants through requiring them to have an inquiring mind when they look at any service that they offer, so that they are able to apply and demonstrate professional skepticism. Then a heightened influence on the importance of accountants being aware of bias in their judgments, and then ensuring that there's a supportive role and the promotion of the correct organizational culture in terms of the performance of any professional services. So the key changes are that a person is required to act in the public interest at all times. One needs to have an inquiring mind. While this is somewhat synonymous with professional skepticism, one needs to differentiate this in terms of making sure that, depending on the type of service that one's doing, your extent of professional skepticism would need to vary as well. And then there have been enhancements to the fundamental principles, for example, to demonstrate how the impact of technology needs to be inculcated in your inquiring mind, I was party to a forensic investigation whereby let's just say the application of this inquiring mind wasn't demonstrated properly, to the extent that the auditor that was being sued by the liquidators actually didn't have a proper understanding of the accounting systems and landed up comparing information from one system to a report that was generated from the same system, thinking they were looking at the two different systems, and said that everything was agreeing. Meanwhile, it was just, presented in different formats. There's also a requirement to be aware of one's biases. Scenario that comes to mind is a person was asked to do a valuation in terms of a shareholders agreement of just thinking of the right words, of the shares in the entity in which they were the auditor. One of the shareholders passed away, and in the shareholders agreement, it said the auditor needs to do a net asset value to determine what is the value at which the deceased beneficiaries need to be paid out. And the matter was going to litigation, to the courts, and the concern that was expressed is that, well, even though the valuation is not going to form part of the audit, well, if the auditor is going to continue acting for one of the parties, well, surely there's a bias involved. Then, with regard to promoting ethical behavior, making sure that that's the accepted culture, and there's a strong strength of character, encourage people to act appropriately. So we've just gone 2 o'clock, so I'm going to propose a 5-minute leg stretch for everybody. So grab yourself a glass of water, quick bathroom break, whatever you need. But I'll see you back in 5 minutes. Right, according to my time, it's been 5 minutes. So can I just have from a show of hands, if you can raise your hands if you are back, please. Your hands raised, don't lower them. I'm just trying to see who's back. I've only got a quarter of you back, so I'll wait another minute. Thank you. You can lower your hands. I'm going to literally wait another minute, and then just in the interest of time, we'll have to continue. Right, we're going to be starting, so you can lower your hands, please. Any questions, please do post them in the chat. A few of you with your hands raised, if you can just lower them, please. Luke, Dan, Maria, Dawood, and Eunice, your hands are still raised, if you can just please lower them. Right, thank you. Right. Somebody lowered them, and now I think somebody, I don't know if that was you, Danny, and now they raised again. So if we can just address that, thank you. So when it comes to the 5 fundamental principles, so in section 111, deals with integrity, and section 112, objectivity. Section 113 is professional competence and due care. 114 is confidentiality, and professional behaviors in section 115. And it's in sections 11 with regards to integrity, objectivity, and professional behavior, the role and mindset has been amended or enhanced. And that's where what we're going to be discussing, spending a bit more time now understanding. I think professional competence and due care is self-explanatory. And I think we should all be familiar with the confidentiality requirements. So when it comes to integrity, one needs to act in a way in which the behavior, the conduct is fair in all dealings and truthful. And there needs to be a strength of character to act appropriately. You know, I think this is a very difficult one to discuss in the South African context when we see what's been happening with government, and in particular with whistleblowers, and looking at the repercussions and how there's not been adequate protection for them. In terms of integrity, the clarification of the code is to stand one's ground when confronted with dilemmas and difficult situations, and challenging others as and when the circumstances warrant in a manner that's appropriate to those circumstances. I'm aware of a registered auditor who was called to a audit committee to discuss his proposed qualification around the going concern of a particular entity. And there was a certain minister from our government who was present at that meeting and almost insisted that he amend his audit report because they didn't want this state-owned entity to be have a qualified audit opinion. And the person said, well, my code says this, my auditing standards say this, therefore I have no choice but to qualify. In terms of objectivity, so this definition was revised in that one must exercise objectivity to ensure that professional or business judgment is expressed in a way whereby it's free of bias, there's no conflict of interest, and there's no undue influence or reliance on individuals, organizations, technology, or other factors. And then when it comes to competence and professional competence and due care, so a practitioner is required to maintain their professional knowledge and skill at the level required. That would be dependent on the types of services that you are doing. They need to act diligently in accordance with the technical and professional standards. Those working in a professional capacity under the auditor's authority need to have appropriate training and supervision so that they can carry out their responsibilities. And a person needs to be competent to perform the engagement, and that's critical before you take on any engagement. When it comes to the expansion, so when it comes to technology, one needs to make sure that one is up to date with new technology, with understanding accounting systems. You know, I was asked by Danny, he was looking for somebody that had experience in a particular IT software, and I said, thanks, Danny. And sorry, Stan and I were chatting about that. I said, sorry, not my area of expertise, something that I can't get involved in. And what's important is that the professional competence and due care around IT is enhanced, particularly where you've got accounting systems that use new IT applications to make sure that that is then appropriately understood.
Can I ask, sorry, Luke keeps raising his hand. Is there something you want? Because I've asked, is there a question you just, was it anything you specifically need to ask, Luke? Carry on in the meantime, Edwin, but I'm just saying, if Luke can please type out if there's a question, because...
Thanks, Danny. Right, when it comes to confidentiality, so just being alert to the possibility of inadvertent disclosure, including in a social environment. You know, my wife, for example, works at the Jewish Court of Law, and she's obviously bound in terms of her work that she does by confidentiality. And then when I hear something, you know, in my social circles, I sort of say, you know, are you aware of this? And obviously, you know, she's known about it for a month or 6 months, and she hasn't said anything. What's important when it comes to confidentiality is that the information must be maintained as confidential within the firm, and confidentiality extends to prospective clients, and then obviously outside of the firm, one can't disclose anything that's confidential unless there's a legal or professional duty to do so. And then one cannot use any confidential information for personal advantage. Yeah, I've covered that. With regard to professional behavior, so as we said, you need to comply with the laws and regulations applicable to the engagement for which you are rendering the services. One needs to behave in a manner that is consistent with a professional's responsibility to act in the public interest in all professional activities and business relationships, and then avoid conduct that the auditor or professional accountant knows could discredit the profession. There have been further enhancements to say that this needs to be consistent with the profession's responsibility. There needs to be appropriate act in accordance with the public interest and needs to be applied in all business relationships and across all business activities. So then let's look at what is happening in the code of professional conduct, and particularly around the conceptual framework. So there's been no changes in section 120 that deals with the fundamental principles around the exercise of professional judgment, other than what we've discussed, but that we need to exercise professional judgment wherever we have the need to apply professional to apply our minds. And then the use of the informed and third party test has been incorporated, and it's been repeated here to say that it needs to be focused on when you are applying your mind. It's the need to have that inquiring mind we spoke about briefly. That's just in terms of the application of the professional conduct, the conceptual framework, that's where that needs to be applied. So what does it mean having an inquiring mind? Previously, the requirements were that one needed to remain alert for new information and to changes in facts and circumstances, and application material when considering the source, relevance, and sufficiency of that information, or when new information has emerged or there have been changes to facts or circumstances. Now what we're required to do is, part of that inquiring mind is to look at the source of that information. Where is it coming from? Can that be trusted? Once we're satisfied with the source, what is the relevance of that information? Is it directly applicable to the service that we're delivering? Does it give us evidence if we're doing an auditory review? Is that information adequate? This is applied in terms of all services, no matter what we do, when we do it, how much of the work we do, and what the of that work is. Effectively, we need to be open and alert to the need for further investigation or other action. So if there's any doubt or concern, we need to make sure that we look further and ask additional questions, get additional evidence. When is this need to be applied? When identifying, evaluating, or addressing threats to the fundamental principles. So if you're not sure if you could be in breach of one of the fundamental principles, say integrity, well, you need to find out. You need to ask further information. One can't hide behind and say, well, actually, I wasn't really, I thought there was a problem, but I didn't dig further. This is a prerequisite for applying the conceptual framework and applies regardless of the type of services that you are delivering. And auditors are required to exercise professional skepticism, which includes a critical evaluation of the evidence, the critical assessment of the evidence, in addition to just this concept of the inquiring mind. So considerations need to include, but are not limited to, when you get new information or there have been changes in information, considering the source and relevance of that information. When new information has emerged, have there been changes in facts and circumstances that led to that information, or is there a concern that that information may be biased? Being alert that information may be missing, and therefore the facts or circumstances may not be fully disclosed. Is there any inconsistency in known facts and circumstances of the auditor's expectation? And then, does the information provide a reasonable basis upon which to reach a conclusion? And whether or not there are other reasonable conclusions that could be reached from the information obtained, in which case then one may, if one's favoring one of the over the other, one may be subject to some bias. So in terms of a professional accountant, there's a need to apply professional judgment. And what does that include? That's the application of the relevant training, professional knowledge, and experience to the facts and circumstances with which the practitioner is faced, taking into account the type of work and extent of work that will be required and the interests and relationships involved. What is the requirement in the code? One needs to apply the conceptual framework in order to make properly informed decisions. One needs to consider all different courses of action that could be available and determine whether such decisions are appropriate in the circumstances. The registered auditor, once again, or professional accountant, would need to ensure that, based on their experience, is an appropriate conclusion reached? Do they have sufficient information to reach that conclusion? Is there a need to consult with any other parties that may have specific expertise or experience? And take a step back to make sure that any preconceptions or biases that may be affecting the professional accountant or auditor in the exercise of their judgment. Right, I don't know if there's any questions. If not, we're going to move on then to the reasonable and informed third party test. Right.
There was a question by Sam, but it was regarding AI. But I don't know if it's pertinent to what we're discussing now.
Sorry, let me.
Minimized it already. It was asking about should we work with ChatGPT, the AI, to a certain extent, or rather avoid it altogether. It was when you were talking about applications and software, I think.
Sorry, just repeat the question there, Danny.
Should we work with ChatGPT, artificial intelligence, to a certain extent, or rather avoid this altogether? Sorry, maybe a bit off topic of the current slide. It's when you're asking about other technologies about 10 minutes ago.
Right. Yeah. Look, I mean, in terms of AI, I do believe that, you know, it has its uses. If one's going to be utilizing it to perform one's services, be very careful, because you can get very generic things, you know, in terms of writing management reports and those sort of factors. But from the perspective of, you know, I don't think there are many clients using it at the moment. At least I'm not aware of clients using that very much in their accounting systems at the moment.
I'm looking at a presenter to do it next month. So I said, told her not to. I'm going to try to get someone to present on it next month.
Right. Okay. Thanks, Benny. Let's now have a look at reasonable and informed third-party test. There is a requirement that when one's faced with an ethical dilemma, that one is able to take a step back and see whether or not the decision that one's arrived at is appropriate. So how then does this play out in practice? So we need to make sure that if we are faced with an ethical dilemma, that we have sufficient information so that a third party would be able to arrive at the same conclusion, taking into account all the facts and circumstances that are known or could reasonably be expected. A person could be reasonably expected to know. Meaning one can't hide behind to say, well, I wasn't aware of that. If it's something that you should have suspected, then you should have asked the question. And obviously, one needs to look at this at the time the conclusions were made. The expectation is somebody with the same level of professional knowledge and experience would arrive at the same conclusion, and that they would have been able to arrive at that in an unbiased manner. So, with regard then to the application of the reasonable and informed third-party test, you know, for example, applying the conceptual framework has one considered and identified which of the fundamental principles are being challenged? Is the understanding of what's transpired sufficiently detailed and appropriate so that the conclusion being expressed is the correct one? When we look at addressing threats, well, there may be threats with different responses, but we need to have a look-back approach to determine whether or not the risk, the threat, has actually been reduced to an acceptable level. And with regards to independence, is there still a risk of independence as it appears, that independence in appearance, whether or not that has been mitigated to a sufficient level. So let's have a look now at the enhanced conceptual framework. And we've got the 5 fundamental principles together with independence. We've got professional competence and due care. We've got integrity, objectivity, confidentiality, professional behavior, and then the all-important independence. So what types of threats could be present? You could have a self-interest threat that could be financial or another interest which could inappropriately influence your behavior. I've been appointed as an external quality reviewer for a medium-sized auditing engagement because the firm was of the view that because the managing partner, even though he's not involved in the audit, has got a family member on a board, that nobody in the firm would be able to perform the services without some sort of self-interest threat or possible intimidation due to undue influence. And therefore they said, well, to mitigate that risk to an acceptable level, they needed to get an external quality reviewer. In terms of self-review threat, based on previous involvement or involvement of other staff on the engagement, one won't be able to apply one's mind objectively. Advocacy is promoting a specific client position. I know when I qualified, we didn't have these independence requirements, and it was common for an auditor of a listed company to get paid in shares of the entity that they were sometimes helping to list. And then familiarity, being too sympathetic or too accepting of the behaviors of a client because of a long continued relationship. So what is the process that one needs to follow for dealing with potential ethical threats? So it's a 3-step process. We need to identify the threat, we need to evaluate the threat, then address the threat. So in terms of identifying the threat, one needs to understand which fundamental principle is being questioned. For example, it could be independence, because if one's doing NAS, non-assurance services, as well as the audit, well, there's a potential independence threat. So now one needs to understand what the services are, understand all the services that the entity is performing, or that the practitioner is performing for the entity, and then understand what code says, which services are permitted, which services are prohibited. Then we need to go to step 2. I'm just going back a slide, which is to now, we've done it, step 3, which is now, we've done step 1 and 2 together. We now need to address that threat. And there are 3 ways to address a threat. We can either eliminate it, we can decline or end the professional activity, or we can introduce safeguards, provided the safeguard will be reduce that risk to an acceptable level. And what's important is that safeguards aren't always applicable because particularly where you're dealing with a public interest entity, you often are only left with the other two options. So, eliminate the threat could be, I don't know, you've got shares in an entity, resign from the, sell the shares. You've got a employee that has a familiarity threat with some staff at the engagement, don't include them on the engagement. But sometimes, you're unable to do that and there aren't any safeguards, and then you have to decline the engagement or end the professional service activity. For example, if it's a statutory audit and you've been doing the audit for 5 years and you don't have another partner to rotate it to because you're a one-man practice, well, then the code around independence says you need to comply with the local legislation, which says 5 years is the limit. So another aspect to consider is conscious or unconscious bias. That is where we may not be acting with the appropriate level of objectivity. And bias can be broken down into different subsections. You can have anchoring bias, which is a tendency to use an initial piece of information as the base against which all other information is assessed. For example, judgment is clouded by the first impression they have of a client or management. I always say that the worst thing an auditor can do when they're planning an audit, at that audit planning, the engagement team planning meeting, is say, look, we've worked with the client for 10 years. We trust them. There's no chance of fraud. They're honest people. There goes professional skepticism and an inquiring mind out the window. And then automation bias is where you favor output generated from an automated system, even when human reasoning or contradictory information challenges whether such output is reliable or fit for purpose. For example, a person acts on the output of, Sam, this one's for you, AI-enabled system without questioning the results. So we need to be careful where IT is involved and we blindly rely on that because, well, the IT's done it, therefore it must be correct. One needs to be also very cautious and alert. Just because it comes from an automated system doesn't mean the completeness and accuracy of that system-generated report is correct. Forms of bias is availability bias. Because certain information is more readily available, well, therefore that's what we're going to use. But that doesn't necessarily mean it's the most appropriate under the circumstances. One needs to look at what-if models, taking the questioning mind approach to see what other common ideas or alternative scenarios could be in place. And then confirmation bias is the tendency to place more weight on information that corroborates a person's preconceived belief rather than looking at the information which is contradictory or casts doubt on that. For example, you have a preconceived belief that revenue should have gone up, but you aren't focusing on the loss of contracts or things like that. And this could apply to a review, audit, or compilation. Forms of bias is where there's tendency where a group of individuals will either encourage or discourage a particular response as a result of a decision being reached without any critical reasoning. For example, a team that lacks adequate diversity to use an AI-enabled audit procedure. Some firms have developed IT software, the use of cats, the use of testing controls, and if the team doesn't understand how the AI works properly, then there's a risk that the procedure will just be performed and it won't be effective. The forms of bias include overconfidence bias, where one overestimates one's ability to make accurate assessments of risks, or has a heightened view of one's own ability in terms of carrying out procedures. I always say that where this, to me, often comes in is, imagine if management needs a specialist in the area. How is it possible that the auditor doesn't need a specialist to check management? This can be something where you've got a bit more complex estimates. Could be share-based payments, where you've got potentially those pension funds where an expert was called in. Could be complex stock. If you're doing the audit of a diamond company, you're auditing agriculture, silos, complicated grain calculations to determine expected yields and harvest values. And then 3 more types of bias to consider is representation bias, whereby based on one's understanding of patterns or experience beliefs, it's assumed that such information is representative. For example, a forensic auditor's assessment of the risk of money laundering is occurring is swayed by the ethnic culture of the owner in the firms. I was involved in a quality review whereby there were back-to-back loans in a group scenario. Subsidiary 1 invested, let's say, 10 million rand with a bank, and subsidiary 2 borrowed 10 million rand from the bank obviously, as we all know, when you invest with a bank versus when you borrow, there's a huge interest rate differential depending on the risk. And this actually turned out to be a money laundering scenario. Then looking at selective perception, whereby a person's expectations to influence how the person views a particular matter or person. For example, the auditor believes the team is happy at work and therefore perceives all the team's responses as more positive than they actually are. Then finally, finally what we need to do is, well, how do we mitigate bias? And that is objectively seeing if we need an expert's input on the matter, consulting others to ensure that we can appropriately challenge information and critically evaluate information, and making sure we receive training related to the identification of bias so that we can address it and be alert of it should it be present. So in the application of the conceptual framework, the organization of a firm has a huge, or is a significant driver in terms of how the conduct of the firm and the ethical culture of that firm. And that would be impacted by whether leaders promote the importance of ethical behavior and demonstrate accountability, the level of focus on education and training programs, as well as performance evaluation and reward criteria to determine whether or not there's any link to quality and ethical behavior. Ensuring that there's encouragement and protection for whistleblowers if they respond, and what is the adherence to ethical values in dealing with third parties. When I was at a firm working on a consulting basis before I started Consulting, we had a client that requested me to backdate certain reports so that they could comply with their requirements of the auditing standards. And the scenario played itself out whereby I was called to a meeting by the partner in front of the audit manager, and I was told that I will date my report the date at which they'd signed the audit report, even though I hadn't completed my work yet. Thankfully, the people I was working with were ethical as well, and went back to the office and we drafted the partner an email stating that we could not assist them in not complying with their own ethical requirements, and therefore, it's up to them if they want us to continue, or we're happy to resign. So the culture of the organization is important, and the culture of the organization stems from the new quality management standards and the system of quality management, the way in which the firm has designed, implemented, and operates its system of quality management, because that determines or has a direct impact on the extent to which ethical compliance is appropriate. So when it comes to professional skepticism, well, the first fundamental attitude we need to have is to question everything. Being alert for conditions which may indicate possible misstatements due to error, fraud, having a critical mindset. The Urban Code has increased the prominence of professional skepticism in compliance with the fundamental principles, and therefore professional skepticism needs to be applied by auditors or any professional accountant in the carrying out of an audit, review, or any other assurance engagement. Skepticism, as we've said, is the process of applying reason and critical thinking to determine the validity of information. One needs to make sure that one applies a critical evaluation of that information so that one doesn't just find information that supports their preconceived conclusions. On the other hand, one needs to distinguish between a cynic and somebody who's skeptic, because a skeptic evaluates, verifies, and concludes, whereas a cynic is just somebody that's inflexible and distrusts most information. I remember when I was in articles, some 3 decades ago, almost, there was a certain clerk that just didn't trust anybody, and they were convinced that people would be changing her working papers, and every time she did a working paper, she kept a copy of it, which, I think is a bit extreme. And one needs to make sure that one manages time pressure, because time pressure is one of the biggest inhibitors to the application of professional skepticism. Right. In terms of one of the Urban Code enhancements with regards to the signing conventions for reports or certificates. So if you are a registered auditor, you are not allowed to delegate your authority to anybody who is not an RA or somebody who hasn't got the appropriate authority as an RA, as a partner at a firm. That can only be relaxed under emergency situations, whereby, for example, there is communication to the client upfront, and the RBA is informed, and prior consent is obtained for that party to sign off. With regard then to the new inclusions around objectivity, we touched on this. If you are a qualified a registered auditor, ISQM2 deals with the requirements of an external quality reviewer, and particularly focused on audit and review engagements where you're dealing with a public interest entity. So there needs to be appropriate objectivity of reviewers, external quality reviewers, as well as any other reviewers involved. that they need to sign off on any self-interest threats, self-review threats, familiarity, or intimidation threats. Next section I'd like to address with you is fees and related provisions. And it's in that regard that one needs to look at the fees paid by audit clients at the client acceptance or continuance stage. If, for example, you're negotiating with a firm, a potential new client, if you're an auditor, well, is that audit fee going to be adequate for you to perform the work together with all your compliance requirements based on the risk and give you some return or not? If not, that is a potential scope limitation, and such a client should not be accepted. Are there any self-interest? Also, do you have the technical and professional knowledge to perform the client, to carry out the fee in a sufficient and appropriate manner? And then, are there any self-interest threats? What is the level of fees for assurance engagements relative to any other engagements that you are offering? Is there a commercial rationale for undertaking an engagement? Is there undue pressure to reduce fees? And can that fee be sustained going forward? With regards to fees paid by an audit client, one needs to make sure that the fees are negotiated and paid at the right level of management. That's why in a listed company, it's at the audit committee level. Because otherwise, this creates a self-interest threat and may create an intimidation threat. We've spoken about the setting the fee at an appropriate level. And then if facts and circumstances change or the quality of the accounting records was not at an appropriate level, well, then one needs to be able to renegotiate or reevaluate that fee. Important that one also looks at client acceptance and continuance procedures, as we said, because you don't want to be going into a scenario where you're going to be having a pressure on fees, because that could affect the quality of work. So considerations around fees paid to the audit for the audit client, making sure that the level of fees and the extent to which they have regard to the resources required, taking into account commercial and market priorities. So is the fee set at that right level that you're able to make a return on it? Is there any linkage between fees for audit or non-audit services? And is the fee size appropriate for both? So this actually comes from the context where a lot of audit firms were saying, well, you know what, we'll discount the audit fee because we're making a better return on some of the consulting fees. And that's why you've had these huge debacles happening all over the world, in South Africa included, around the other services, that non-assurance services that have been given to audit clients. Is there any dependency between the level of fee and the outcome of the service? So contingency fees by auditors, by professional accountants, that's not allowed. Are there any fees for services to be provided by a network firm or another firm with which the partners are associated? And then what is the level of the fee in the context of the service to be provided? Is that a fair price to charge? Other considerations include whether or not the operating structure and the compensation arrangements for the firm are appropriate. What is the significance of the client if it's at the firm level as well as at the partner level? If it's above 15% of an individual partner's fees or 30% of the firm fees, that creates a potential self-interest threat. And then what's the nature of the client? Is this a public interest entity? Is that why we're doing the audit? And what's the relationship of the client to the related entities to which the services other than the audit are provided? And then with regard to the discussions and setting the fee, is the appropriate level of engagement with those charged with governance or appropriate management outside of just the CFO or managing partner? Is there any guidance as to what's a appropriate level of fee that should be charged? I'm not aware of anything in South Africa, although I know that the feeling in the market, if any of you do attorney trust audits, I know those need to be in, now called legal practitioners, those need to be in by next week, that 5,000 is inadequate. Whether the quality of the firm's audit work is subject to review by an independent third party, such as an oversight body, and that's very important if you're using other auditors, because that gives you some degree of comfort. So I think before we look at the level of fees, we've got to just after 3 o'clock, nearly 3:05. So I'm going to give you a 10-minute tea break. We can synchronize watches, and if we can be back in 10 minutes time. I'll see you just now. Okay, thanks. Right. Just from a quick show of hands, who's back? Apologies, just lost track of time a bit. I have a good proportion of you back. So I think in the interest of time, let's get going. If you can lower your hands. So with regard to the level of fees, so we understand while that is a business decision, there needs to be an inclusion for technical and professional standards that needs to be factored in, any quality reviews one needs to include in terms of setting those fees. There needs to be a commercial rationale for the fee, and the level of fee can't be influenced unduly by pressure from the client. And where appropriate, a safeguard review may need to be factored in as part of the fee as well. When we look at the impact of other services provided to an audit client, so the audit fee primarily needs to be set independently of any other services, so that the provision of other services is not an appropriate consideration in determining the audit fee. You can't, as I said before, discount the audit fees, or you shouldn't actually discount any fees you're providing to a client. And then cost savings need to be achieved as a result of the experience from the provision of services. One needs to just be very wary of that. With regard to contingency fees, so they need to be determined on a fixed basis. You can't charge in relation to a fee for contingency fee for an audit, and you're not allowed to charge a fee for non-assurance services to provided to an audit client if the fee is charged by the firm expressing the opinion on the financial statements, because you'd have a self-review threat there. If they participate significantly in any part of the audit or its material, or there's any dependency on a future or contemporary judgment related to the audit of the material amount in the financial statements. Any self-review threats are for assurance services are not allowed to be for non-assurance services are prohibited. Factors to be considered are the range of possible fee amounts and whether or not, sometimes people do compliance work and they have a range depending on the volume. That would be allowed. But, other than that, you're not allowed to sort of have contingent fees. Whether an appropriate authority determines the outcome on which a contingent fee depends, there may be leeway. I'm not aware of anything in South Africa where this would give us allowance to include this. Disclosure to intended users of the work performed by the firm on the basis of the remuneration and the nature of the services, as well as the effect of the event or transaction on the AFS. Any work that is done that will then be form part of the audit could be internal controls implementation, could be valuations or accounting work, and then one's going to audit it. That would be problematic. Where a large proportion of fees charged by providing other services to an audit client, or there's a concern of a potential loss that could create a potential self-interest or intimidation threat. And then other factors that are relevant is the ratio between fees for other services versus the audit fee, the length of time that one has been giving the audit services to the client, as well as nature, scope, and purpose of other services, including any recurring services such as, tax administration or secretarial filing, those sort of things, or if there's any laws or regulation that mandate that the services need to be provided by the firm, then that is consideration for allowing those other services. This is very prevalent in sort of medical aids and pension funds, where the financial FSCA, the Financial Standards Conduct Authority, has specific additional requirements and reports that need to be prepared and submitted by the auditors. Overdue fees, one needs to be quite careful with overdue fees, because where they are overdue during the period of the assurance engagement, there needs to be a proper payment plan for such fees before the assurance report is issued. Other relevant factors is the significance of the amount of the overdue fees, the length of time which the fees have been overdue for, and the firm's ability and willingness, so the firm's assessment and ability and willingness of the client to pay those overdue fees. Safeguards could be part payment or the inclusion of an appropriate reviewer, and the firm would need to determine whether or not overdue fees may be a breach of Section 511, being loans to the client. And then the firm needs to determine whether or not it's appropriate for the firm to be reappointed or continue the engagement where there are fees outstanding. With regard to total fees, so when the total fees generated from an audit client by the firm expressing the audit opinion represent a large portion of the total fees of that firm, the dependence on and concern about the potential loss of fees from the audit and other services from that client impacts the level of self-interest threat and creates a potential intimidation threat. And therefore, where there is fee dependency, factors that need to be considered is the operating structure of the firm, the expectation with regard to whether or not the firm can diversify such that any dependence the audit client can be reduced, and what possible safeguards could be implemented, such as an appropriate reviewer who's not a member of the firm or the network, reducing the extent of services of the non-audit services, or increasing the extent of services provided to other clients so that one can reduce that dependency. I know there was one firm where over 50% of their fees from audit work came from one group. Other factors to consider is where at a partner or office, as opposed to the entire network or firm, there may be qualitative and quantitative significance of the audit client. What's the compensation of the partner or partners of the office? And is that dependent on these fees generated from a specific client? And then safeguards could be an appropriate reviewer is not a member of the firm, or increasing the extent of services provided to other clients. You know, those sort of things sound great in theory, but sometimes very difficult to apply in practice. In terms of firm dependency, so the code has specific requirements around firm dependency, where audit clients that are not public interest entities, so when for each of the 5 consecutive years, total fees from an audit client that is not a PIE represent or are likely to represent more than 30% of the total fees received by the firm then needs to determine which safeguard or appropriate action it's going to take to address the threat to an acceptable level. And the options are either prior to the audit opinion being issued on the 5th year's AFS, it is an independent review of that audit, or B, after the audit opinion has been issued and before the 6th year's audit, there is a review by the professional body of that entity. But one of those 2 approaches need to be in place. There is a firm dependency on a non-public interest entity at 30%. If it continues to exceed 30%, the firm shall then in each year determine an appropriate safeguard prior to the audit opinion or after the opinion of the current year, but before the issue of the following year, what they're going to be doing. And that needs to be planned and documented well in advance. Where you've got an entity for which sorry, I just want to have a look at this. Right. Sorry, so where the entity is a public interest entity, so then we, instead of looking at a 5-year, we've got a 2-year evaluation, and where in 2 consecutive years, the fee represents 15% of the total fees of the firm for a public interest entity, then we need, that firm then needs to, because of the public interest nature, it needs to make sure that there is a objective independent engagement quality review that is performed by a registered auditor. Where more than 5 consecutive years have taken place, we said that's then prohibited unless there's compelling reasons for a public interest entity, where we said, remember, that's only 2 years, and they consult with the Independent Regulatory Board of Auditors, and the RBA agrees that the firm can continue as the auditor, that being in the public interest, and there's a pre-issuance done before the audit opinion on the 6th year, then it may be allowed under specific circumstances. In terms of, just want to double check how we're doing for time. In terms of the firm dependency, so I don't think there's anybody that does the audits of banks here. That's where there is a pre-issuance review and non-public interest entities for joint audits. I don't think we need to discuss that. But what is important is that the transparency of fee, and interesting, I've been sitting on a subcommittee of the RBA that's looking for enhanced auditor reporting. And the question is whether or not audit fees are going to be disclosed There's consideration, an exposure draft going out shortly as to the inclusion of even things such as materiality in the audit report. Some jurisdictions around the world have that already. So in a public interest entity, the objective, there needs to be transparency of fees, and there needs to be proper discussion with those charged with governance for them to consider the independence of the firm and the background and the context of the audit fees, the context of the audit fee for the audit of the financial statements, and any non-audit services that are delivered and the value thereof. Communication needs to include the firm's assessment of their independence, and there needs to be two-way open exchange of views and information around the scope and extent of audit work and impact on the audit fee, where we've got these public interest entities. Fees for the audit that needs to be communicated to those charged with governance on a timely basis. What that fee is going to be to the firm or to the entire network. And then also there needs to be open and transparent communication with any threats created by the level of those fees and the safeguards we put in place to ensure that the threats are mitigated to an acceptable level. Fees for other services, once again, there needs to be, if you're dealing with a public interest entity, there needs to be appropriate communication with those charged with governance, what those fees are, what the amounts are, and once again, whether or not there's been any threats to independence, whether or not, how those threats have been reduced to an acceptable level, or if not, the proposed course of action the firm will be taking. With regard to public disclosure of fee-related information, so a firm shall discuss with those charged with governance of an audit client that is a public interest entity, the benefit to the client stakeholders of the client making such disclosures that are not required by laws and regulations. So the extent of reliance, the proportion of fees, audit versus non-audit, even though it's not required, this is useful information to the public, and the information, and that the information might enhance the user's understanding of the fees paid or payable and the impact on the independence of the firm so that they can be appropriately evaluated. Don't know if there's any questions before we go on to the audit versus non-audit services discussion. Okay. So we're going to discuss then the audit and non-audit services. But before we do that, from the code's perspective, we operate in South Africa, and therefore we have additional requirements. And those are firstly, Section 90, subsection 2 of the Companies Act, which speaks about that the auditor is not allowed to perform the audit for more than 5 years in a statutory audit. And further, if they were involved in the preparation of the financial information, that they are not allowed to be appointed as auditor. Those are two critical factors from a South African legislative perspective. And remember, that applies to non-public interest entities, for example, a statutory audit. With regard then to the changes to the non-audit, non-assurance services, so there's been a replacement of Section 600, and Section 600 deals with accounting and bookkeeping services, administration services, valuation services, etc. You can see these, and these are the types of services that are prohibited to public interest entities and potential threats in non-public interest entities. So how then do we respond to this? So when it comes to non-assurance service provisions, this relates to the audit and review of public interest entities. It's prohibited because there is a self-review threat and a self-interest threat that cannot be mitigated. There are stricter prohibitions on certain types of non-assurance services to audit clients, and there needs to be increased engagement and transparency about the independence and non-assurance services with management of the entity. So when does that communication need to take place? Well, the client acceptance stage should be the first time the discussions take place, because it's then that one needs to look and evaluate and address any threats to independence. Before a firm accepts an engagement, they need to determine whether or not there will be any issues in the code or potential risks, because you can't agree to a client and agree to a fee not knowing that, hang on, you need a quality review involved, for example. And then one needs to determine the provision of other services, because that also might create a self-review threat. For example, when the result of the service will form part or affect the accounting records or controls over financial reporting, upon which the firm will express an opinion, or in the course of the audit of the financial statements, the firm will express an opinion, and the audit team will evaluate or rely on any judgments made or activities performed by the firm or network firm when providing the non-assurance services. I'm going to go back 3 slides here and just talk to these slides. You know, accounting and bookkeeping services, we said for a PIE, it's prohibited. For a non-PIE, from a code's perspective, it says, well, provided you don't take on management decision and you're just processing, etc., that could be okay. You may need to put in a safeguard. Remember, in South Africa, if it's a statutory audit, we've got the Companies Act, which says that's a no-go area. If you're doing administrative services, so it depends on what sort of administrative services. Are you acting as on the board of directors? Or are you merely filing statutory returns? Valuation services. When it comes to valuation services, is this an audit of the company, which is not going to form part of the financial statements because it's of the company itself? Or is this an audit of a division which is looking to be sold? Clearly, that's something that would form part of the accounting records, and that would be prohibited, irrespective of a PIE or non-public interest entity. Tax services, so if it's administrative filing of tax returns, etc., based on information that they give you, That's that's fine. If, however, it's tax consulting services, then we've got a different problem because, well, that the auditor needs to express an opinion on the accounting, on the accuracy and completeness of the taxation assets and liabilities and any taxation charge. Internal audit services, you can't provide internal audit services and audit the client because all the controls which form the fundamental basis for risk assessment to determine the likelihood of errors, well, that would then be an immediate self-review threat. Information technology system services. So if you do an IT audit, part of the audit, that would be okay. But that's quite different to if you're consulting to the client to improve their systems, because then those are the very systems that you then rely on. Litigation support services, where you are involved in assisting them either with SARS or in a court case, that acting as some sort of expert witness or something, that could be a problem. The provision of legal services, debt collection, etc. That would have a direct impact on the accounting estimates for provision for doubtful debts. Recruiting services, where you sit in interviews for financial managers or CFOs. That creates a self-review threat. And corporate finance services, be that listing, valuations, mergers, acquisitions, all of those would likely have a direct impact on the financial statement and therefore would be a huge problem. With regard to client acceptance and continuance, as we said, they need to do this, assess the non-assurance services prior to their acceptance of the client. Materiality. So it can be a factor in evaluation of a threat. However, if the code expressly prohibits the non-assurance service to an audit client, then materiality is irrelevant because it is a breach of the code. And additional factors to be considered would be whether multiple services increase the threat compared to each individual service, and then whether each additional service increases the threat arising from the overall client relationship. So when we look then at non-assurance services and factors that can create threats, it's what work is being performed, the extent of that work, and the intended purpose of that service. Very importantly is if the client is a public interest entity, who's managing the employees and the expertise, what is the extent of the client involvement in the determination of significant matters, whether or not the services will impact the accounting records on which the opinion is being expressed, the degree of reliance expressed on the outcome of the service during the audit, and finally, whether or not the non-assurance service, what is that fee relative to the size of the audit fee? terms of the risk of providing non-assurance services, one needs to be very wary and alert for local laws or regulations, which may differ, like we discussed in South Africa. And then also, if you're part of a bigger network, well, making sure that there is proper independence from the services provided by the entire network. So where there is self-review threats from non-assurance services, one needs to apply that reasonable and informed third-party test. One needs to make sure that from a look-back, a step-back approach, whether or not the safeguard that has been implemented is effective, and whether or not the self-review threat cannot be eliminated, because then it makes no difference what safeguard will be put in place. You wouldn't pass the reasonable and informed third-party test. With regard to non-assurance services, they may not be provided if the entity is a public interest entity, or if there's heightened independence expectations because of a prohibition or a self-review threat that cannot be eliminated. Where we've got audits and reviews of public interest entities, we need to look at those prohibitions of the non-assurance services and have a look whether or not the elimination of materiality is a factor in determining whether or not the service is permissible. For a public interest entity, it's unlikely unless you have prior approval from the regulator. And then there may be stricter prohibitions on certain types of non-assurance services to audit clients. And then ultimately it boils down to robust engagement and transparency about the independence and the non-assurance services with the management of the entity. With regard to the advice and recommendations, so it's allowed for a public interest entity. Management responsibility is not assumed, and the conceptual framework is applied with there are no threats, particularly to self-review, that directly impact independence. Advice and recommendations, so relevant factors to be considered is one can give advice on accounting policies or financial reporting standards where that is general generic advice, as well as regarding financial statement disclosures. One can propose adjusting entries arising from audit, but it's management's responsibility to accept them and determine which entries they're going to pass. Recommendations around internal controls, deficiencies, and appropriate courses of action can be made. And the resolution of accounting reconciliation challenges can also be addressed, as well as guidance around group accounting policies and compliance thereof. With regard to non-public interest entities, so that's a lot easier to introduce safeguards. There could be an appropriate review included. Use of professionals not part of the engagement team. Reviewer not involved in the provision of non-assurance services, or clearance of the outcome of the service from an appropriate authority, regulatory authority, such as, for example, SARS, where, you know, it's expat There needs to be certain PAYE calculated, and you get prior approval from SARS. That then wouldn't be an issue. Public interest entities, there's a requirement of enhanced communication with those who have oversight of the independence of the audit firm. That would be audit committees, normally in a public interest entity. And that communication needs to be prior to the provision of any non-assurance services. And the agreement of the process to be followed for communication with those charged with governance also needs to be set out. What is that agreement process? It needs to establish the procedure for the provision of information for non-assurance services, identify which entities would be involved in this process, identify any services to be provided without specific those charged with governance approval based on the general policy, confirm how management of multiple public entities have determined that authority for approving such services, establishing a procedure with those charged with governance to evaluate the auditor's independence to determine whether or not it may be prohibited or it may be limited by professional standards. And then the agreement process needs to specify how any issues not covered by the process will be addressed. With regard to the provision of considerations for related entities, a firm or network may not provide non-assurance services to audit clients normally prohibited, on which the opinion will be expressed to the following related entities. Any entity that has direct or indirect control over a client, so that means the holding company of that client, entity with a direct financial interest, that's a company that has an investment in it, or an entity or loans, or an entity under common control. Provided, however, if they don't express an opinion on the related financials of that entity, then they may provide those services. However, it must be that they do not assume management responsibility, whether directly or indirectly, and the services do not create a self-review threat, and the firm addresses other threats by providing such services that are not at an acceptable level, for example, by the inclusion of a independent objective reviewer. With regards to the provision of non-assurance services to audit clients, they can only be provided where there is compliance with the fundamental principles. That's the independence, objectivity, professional due care, etc. There is compliance with the independence standards, and the conceptual framework for addressing potential threats is applied, being that an identification, evaluation, and appropriate response to threats. So the conceptual framework and the general provisions apply to the provision of non-assurance services. There's no specific requirements, and the application material is there to make sure that that is appropriately evaluated. For those of you, when it comes to these independence ethical features, so in South Africa, we have a legislative framework which sets out IRBA's responsibilities. They have an investigations committee, which once the inspections committee has completed its work, the investigation committee is delegated the power to carry out further investigations to determine whether or not the conduct of the auditor has been improper in terms of the code or any of the standards. And then you then have what is now called the Enforcement Committee, which is then entrusted with the power to consider the Investigations Committee's recommendations and make a determination of the charges that will then be applied for the improper conduct. And then you have the Disciplinary Committee, which is delegated the power to convene a hearing for the process of determining the charges of improper conduct where a auditor has been found guilty, and then imposing an appropriate sanction. In terms of then what this then addresses is any reportable deficiencies, the RBA has to look and determine whether or not they have an impact of the engagement at the firm level. Are there any breaches of the code? And then what is an appropriate course of action? That brings us to the end of the session. I don't know if there's any questions.
Thank you, Edwin. Yeah, so if there's any questions, either you can type it in the query. If there's something you actually need to ask verbally, just put a message in the chat. Say, can I ask? Yeah.
So, Edwin, thanks very much. Nobody can fault you for not being thorough. I mean, I don't think there's anything you left out. I couldn't find anything. So this audit of this session was very good. And you passed with flying colors. And thank you really for your time and your effort, which I can see is a supreme effort. You really put this together in a very understandable and clear, concise manner. I feel sorry for the poor auditors that have to adhere to this, but from a point of view of knowing what's going on, it's been great. Thank you, everybody, for attending. I don't know if there's any questions. I see there is one question. Danny, you want to
just Sam saying thank you again.
Sam. Okay.
There was a note in the chat about that Wesley mentioned a few minutes shortly ago about that the auditor rotation is no longer mandatory. That he's saying that the East Rand CAA Association won its case over the over this. So just I don't know if anyone else saw it.
Just to comment on that. Yeah. So very interesting that the East Rand division of SAICA took the RBA to court. And there was a response by that. I mean, what came out is that what the RBA did around mandatory audit firm rotation, which was to be in place, I think it was 2023 this year, that firms had to start rotating. But and remember, that was only applicable for public interest entities, so your listed companies, etc. And while I'm not going to go into the merits or demerits of mandatory audit firm rotation, the RBA has subsequently come out with a response saying they are not going to be taking that on appeal. But what they have said is that they will look internally to see what they need to do, and it may actually lead to change in the Auditing Professions Act, and then they promulgate it that way, saying that, well, this is the new law, as opposed to this is what they want people to do, which is what was found to be unconstitutional. Having said that, what was interesting is that despite the rule having been, or the court having found that this was unconstitutional and that it was no longer enforceable, there were two audit there were two listed companies post that communication that voluntarily decided to change their auditors, and they said, fully aware that this has been rescinded, but they're still changing. So I don't think it's affecting many people in small practices, but I think it's a matter of time before it'll come about in terms of change in legislation.
Right. So thank you. Those of you who haven't received your certificates yet, we're busy with them, and if you haven't paid, then please pay and we'll send the certificate. There are some new seminars planned, webinars planned for the rest of the year, and we'll be circulating the notices in due course. And once again, thank you, Edwin, for your work today, and thanks everybody for attending.
Thanks, Stan. Thanks, Edwin. I'll see you next month.
Okay, be well. Cheers.
Cheers, everyone.